Article 136 of the Indian Constitution provides for special leave to appeal by the Supreme Court. Under this article, the Supreme Court, in its discretion, grants special leave to appeal for any judgment, decree, determination, sentence, or order in any cause or matter passed by any court or tribunal in the territory of India. But it does not apply to any order or judgment constituted by or under any law relating to the armed forces. The case of Universal Sompo General Insurance Company Limited versus Suresh Jain deals with the maintainability of Article 136 of the Constitution against the order passed by the National Consumer Disputes Redressal Commission on appeal or revision petition. Quickly moving on to the facts of the case, the respondent bank, acting as an intermediary, issued insurance policies covering up to rupees 50 lakh for the risk of fire and burglary in favor of the complainant through Universal Sompo General Insurance Company, the petitioner in this case. After the complainant suffered theft and a fire outbreak at his premises, he filed a claim for rupees 49 lakhs. The petitioner repudiated the claim on account of the non-submission of documents, against which the complainant approached the State Consumer Disputes Redressal Commission. The SCDRC partially allowed the complaint, and thus the petitioner and the respondent bank were jointly and severally liable for the deficiencies in providing service to the complainant. The petitioner, agreed by the order of the SCDRC, challenged the same before the National Consumer Disputes Redressal Commission, which was dismissed. Therefore, the petitioner approached the Supreme Court under Article 136 of the Constitution against a dismissal by the NCDRC. Now, the main issue which was raised in this case was whether the court should entertain the petition seeking special leave to appeal under Article 136 of the Constitution directly against the order passed by the NCDRC in exercise of its appellate jurisdiction, or relegate the petitioner to avail the remedy of filing the writ petition under Article 226 of the Constitution, or a petition invoking supervisory jurisdiction of the Jurisdictional High Court under Article 227 of the Constitution. The Supreme Court in this case ruled that the National Consumer Disputes Redressal, that is the NCDRC, orders cannot be directly challenged before the Supreme Court by a way of special leave petition under Article 136 of the Constitution, unless the order was passed in exercise of NCDRC's original jurisdiction. The division bench of Justices G.B. Paridwala and Manoj Mishra explained that under the Consumer Protection Act, the remedy of a direct appeal before the Supreme Court is only available in respect of the orders passed by the NCDRC in exercise of its original jurisdiction. In other words, no such appeal before the Supreme Court would lie against any order that are passed by the NCDRC in exercise of its appellate or revisional jurisdiction. The remedy of appeal to this court is available only with respect to the orders passed by the NCDRC in exercise of its powers conferred by Section 21, Clause A, Subclause 1 of the Consumer Protection Act 1986 and Section 58, Subsection 1, Clause A, Subclause 1 or Subclause 2 of the Consumer Protection Act 2019. In other words, both the acts provide for the remedy of appeal to this court only with respect to the orders which are passed by the NCDRC in its original jurisdiction, and no further appeal lies against the orders which are passed by the NCDRC in an exercise of its appellate or revisional jurisdiction. The bench reasoned that the Supreme Court's power to grant special leave to appeal under Article 136 can be invoked only in very exceptional cases by citing the case of Pritam Singh versus State. Such circumstances include where a question of law of general public importance arises, or where a decision is taken which shocks the conscience of the court. The bench proceeded to opine that when a court has an alternative remedy to go before a high court, the Supreme Court should not entertain a special leave petition and thereby short-circuit the legal procedure prescribed. The Apex Court relied on the decision of in Faison versus Omax Buildhope Private Limited, which was reported in 2022, where the Apex Court held that the remedy available to the aggrieved party against the order passed by the NCDRC in appeal under Section 58, Subsection 1, Clause A, Subclause 3 or Subclause 4 would approach the concerned High Court having jurisdiction under Article 227. The said decision explained the importance of approaching the High Court where a remedy is available under Article 227 of the Constitution. Therefore, the bench ordered the petitioner to first go before the jurisdictional High Court, either by way of writ petition under Article 226 of the Constitution or by invoking the supervisory jurisdiction of the jurisdictional High Court under Article 227 of the Constitution. In that note, the court dismissed a special leave petition without considering its merits. The court also added that after the High Court renders its final order, it is always open for either of the parties to then come before the Supreme Court by filing a special leave petition under Article 136 of the Constitution. Thank you.